Thank you, Mr. Hibner, and thank you to both counsel for agreeing to conduct your oral argument via live streaming video conference over YouTube and Zoom. And the hearing is not only being broadcast live as we speak, but it will be posted on the Administrative Office of the Court's webpage for future reference if you and or the public wish to reference it. We will conduct the hearing today in the same fashion as if all of us were sitting in the courtroom together. The appellant will have 15 minutes and may reserve up to 5 of that for the argument. And then, of course, the appellee will have 15. Are there any questions or announcements?
Hearing none. The appellate gunner. Not from the appellate gunner.
Thank you.
No, Your Honor.
Governor, please call the case.
George E. Chittenden et al. Versus BRE/LQ Properties LLC.
All right. Thank you. Please proceed.
Good morning, Your Honors.
Morning, Mr. Judkins.
My name is Joe Judkins, and I'm the attorney for the plaintiffs, appellants George Chittenden and Leah Chittenden. This matter is a slip and fall case on ice at a La Quinta Inn and Suites in Nashville. I would like to reserve 5 minutes for rebuttal.
Very good.
The defendant was negligent in this case, and the negligence of the defendant caused the plaintiff, George Chittenden, to slip, fall, and be injured on January the 16th of 2018 at the La Quinta Inn located at 2345 Atrium Way in Nashville, sometime between 11 a.m. and 12 noon Central Time. The trial court granted the defendant's motion for summary judgment, finding that a property owner is not required to keep its property free of snow and ice at all times, but is required to clear the snow and ice within a reasonable time after it has accumulated. As I understand Judge Jones's ruling, the trial judge's ruling, the defendant was found to have acted reasonably under the circumstances. The appellants assert that the trial court erred in granting summary judgment, and jury questions remain regarding the reasonableness of the defendant's efforts or the defendant's failure to act reasonably under the facts of this case. The appellee takes the position that there is no duty on the property owner's part to remove snow and ice until it has accumulated. I believe that is a proper recitation of the general rule. However, one can assume a duty, and if it does, it must act reasonably. In this case, if it pleases the court, the landowner assumed a duty to remediate the icy conditions by its actions. Specifically, the property owner did assume the duty in the following particulars. La Quinta representatives assumed that duty, first of all, by calling its usual agent and representative, David Elliott, who handled such matters, that is clearing ice and snow and such other dangerous conditions on his property on the day that the snow was falling, that is January the 16th, 2018. She did so just a few moments before Mr. Chittenden's fall.
Excuse me, Mr. Judkins, what can you specify the nature of the duty you're saying that La Quinta assumed?
The duty that La Quinta assumed, Your Honor, would be to keep the property free of dangerous conditions, including snow and ice. And
okay.
We say that perhaps if they did nothing, they might not have any duty, but they did assume the duty by, first of all, calling their representative their agent. So, and the duty that they failed to follow that they had was to keep the property free of snow and ice, and to clear it and to make it safe for patrons there at the La Quinta Inn.
Mr. Judkins, is it fair to say that from your perspective, there's no question that the La Quinta Inn owed a duty, but the question is for us to consider is whether they breached that duty by not.
That is correct. Well, and
not timely.
Your Honor, I guess the first the threshold question though would be whether there was a duty because of the facts of this particular case. The snow had stopped. Well, excuse me, the snow was still ongoing when Mr. Chittenden fell. And of course, the defendant's position is that there was no duty for them to clear the snow and ice while the snowfall was ongoing. And we say that they assumed that, though, even though the snowfall was ongoing, by the actions that I was reciting earlier.
All right, thank you.
And then we also say that they assumed the duty by putting down ice melt prior to the time.
I thought you had disputed that fact on the motion for summary judgment. One of the statements of undisputed facts was that Mr. Elliott had spread ice melt on the lot prior to the plaintiff's arrival, and you disputed that. So now you're saying that that's undisputed?
That is that we're saying that is undisputed, and that's consistent with what the appellee is saying, that they did put it down prior to the fall. And we also, the employees who were located there at the La Quinta Inn also put down ice melt prior to Mr. Chittenden's fall. And they put it on the walkways in the area where Mr. Chittenden was walking.
So, Mr. Judkins, would you say then that this is all a question of law then for us? There's no disputed material facts here. We're just deciding how these facts come out in a question of law.
I think that's generally true. I think all of the material facts, Your Honor, are undisputed. There may be some minor matters that are in dispute, but I feel like, and it's our position, that all of the material facts are agreed upon.
Okay.
So, and we say that the court, in looking at the facts, those undisputed facts in the light most favorable to the appellants, the plaintiffs in this case, the court should find that the defendant had a duty that it assumed, and that it failed to fulfill its obligations under that duty.
Now, Mr. Judkins, let me ask you, when you say that the facts are undisputed, do you mean the facts that were found by the trial court in its order?
No, Your Honor, I do not. I say that the facts are undisputed based upon the record, and in looking at the order, the order is pretty conclusory. And if I can,
okay, let me ask you this now. The order says that there were 2 inches of snow on the ground when the plaintiff arrived. Is that material?
That is material, and that's undisputed.
Okay. And then said when the plaintiff entered the hotel, the snow was still falling.
That's undisputed,
Is that-
Your Honor.
Okay. And that the plaintiff left the hotel about 10 or 15 minutes after entering the hotel.
That fact is undisputed, Your Honor.
All right. And so what other facts, undisputed facts, do you say are material to the summary judgment?
The fact that the La Quinta Inn enlisted the aid of their agent and representative, David Elliott, before the fall and while the snowfall was ongoing to clear the area of ice, and that the people at La Quinta, the employees there, put down some ice melt, and also that David Elliott put down some ice melt all prior to the fall of Mr. Chittenden.
Okay. Okay. Thank you.
Very good. Is your time's almost up, Mr. Judkins, so we'll hear from Mr. Embry.
Thank you, Your Honor.
Thank you, Your Honor. May it please the court, James Embry of the Nashville Bar. It's a pleasure being in front of the justices this morning. Your Honors, Judge Kelvin Jones got it right. This case and the facts of this case and the undisputed facts of this case are amazingly similar to the Bowman versus State case that this very court, the Court of Appeals Middle Section at Nashville, rendered an opinion on. That's 206 Southwest 3rd 467 in the year 2006. It's so rare to have a case so on point. If I may beg the court's indulgence briefly for some facts here from the Bowman case. The ice storm at issue in this case did not begin until 3 a.m. on the morning of March 15th, 1999. This honorable court stated that the state had no duty to monitor the weather conditions during the evening hours of March 14th or the early morning hours of March 15th, and likewise had no duty to initiate measures to prevent ice from forming on the parking lots at the RS Gas Office complex. And of particular importance, Your Honor, the state's duty extended only to removing the ice from the parking lot within a reasonable time after its formation. In the case at hand, Your Honor, plaintiff left East Tennessee the morning of January 16, 2018, early. He wanted to see a Predators game in Nashville that evening. He was well aware of the snowstorm and he wanted to leave early and trying to get to Nashville before there was too much accumulation. It began to snow moderately to heavy around Cookville or Crossville. When he then arrived at the hotel at 11 a.m. the morning of the 16th, January 2018, it was still snowing, uncontroverted, undisputed. Plaintiff then proceeded to walk into the La Quinta Hotel, which I represent, while it was snowing. He traversed 2 inches of snow across the parking lot, came into the hotel, checked in, put his bags in his room. No more than 10 to 15 minutes passed. And as counsel for plaintiff advised, as he left the La Quinta facility, it was still snowing. Thus, accumulation was still occurring. The Bowman court stated unequivocally that property owners cannot be held liable for failing to remove natural accumulations of snow or ice when they had no notice of the condition, or forecasts of snow or ice do not by themselves constitute actual or constructive notice of dangerous conditions, requiring a property owner to begin taking steps either to prevent or to remove accumulations of ice or snow. This honorable court went on to state that,
Embry,
yes,
your client had noticed that there was snow accumulating in its parking lot. So that really doesn't apply, as it isn't the question of when should they have started the removal process. They had knowledge of it.
thank you, Your Honor. Yes, an ice melt was laid the early morning hours prior to the fall. This honorable court addressed that when it stated that a property owner is expected to take reasonable steps to remove snow and ice within a reasonable time after it has formed or accumulated. It was still accumulating, Your Honors, when Mr. Chittenden experienced his fall. Judge Kelvin Jones noted this and relied heavily on this case law because it was so on point. Judge Jones stated, "The court finds there is no genuine issue of material fact that the defendant did not breach any duty to the plaintiff." The court, Judge Jones, the trial court, relied on the holding of Bowman versus State of Tennessee and quoted the language that I just quoted to this honorable court. Again, finding there is no genuine issue of material fact. Of note, the next to last paragraph of the order of Judge Jones stated, "It is further the finding of this court that the defendant's duty extended only to remove the snow in a reasonable time after its accumulation." And Judge Jones found that under the circumstances in this case, there is no reasonable expectations that the premises would be free of snow within 10 to 15 minutes of the plaintiff entering the building. And for these reasons, the court granted the motion for summary judgment. It was noted an issue that I felt needs to be mentioned to this honorable court about a failure to warn. We noted, we being the defendant, noted in our brief of Blair, we noted the case of Blair versus Westtown Mall, where the Court of Appeals held that the duty is either removing the condition or warning against. It was removed. The snow after accumulation was removed, and that's an undisputed fact. Plaintiff testified in his deposition that when he came back from the hospital from his unfortunate fall, the parking lot was cleared. David Elliott, the individual who took care of the parking lot for La Quinta, testified that he got out to the La Quinta parking lot as soon as the roads were safe enough so that he could get his equipment to the parking lot to clear it. Your Honors, I will not belabor the point. I believe this fully sets out the argument of La Quinta and Applee. And for these reasons, we assert and request that this honorable court affirm the trial court's finding that the motion for summary judgment was well taken and granted. Thank you.
Thank you, Mr. Emery. Unless there's any questions, we'll hear from Mr. Judkins.
Thank you, Your Honor. Bowman versus State is not on point in this case. It is our position. That was basically a directed verdict by the Claims Commission after a full hearing. There was not a grant of summary judgment in that particular case. In that case, also, the issue of assumption of duty was not at issue. That never was raised as an issue at the hearing level or at any time. So we say that the facts of Bowman versus State are significantly different than this particular situation. In that particular case, there was no assumption of the duty by enlisting an agent to clear the area prior to the fall. There was no placement of ice melt on the premises by either an out of property agent or by an owned property agent. And in regard to the agents coming to the property, the proof is in the record that the agent endeavored to get there as soon as he could, meaning that he was going to attend to that as soon as he could get to the property. So the movement was afoot by the defendant to remediate the snow and ice problem.
Mr. Judkins, your argument seems to be that if La Quinta had done nothing, you know, and the plaintiff fallen, the defendant wouldn't be responsible because it hadn't assumed any duty.
Your Honor, that's a bit ironic, and it doesn't make a lot of sense to me personally, but I believe that is a correct recitation of the law. They don't, if they do nothing until after the snowfall is over, then they're home free. But if they do, they've assumed the duty, and that they're subject to doing that reasonably.
And what proof is there that what they did was not reasonable?
Well, the proof in this, that would be a jury question, of course, that would be.
No. What evidence was introduced to say that what they did was not reasonable?
There was no proof introduced except that the fact that this gentleman fell and that there was snow and ice there, and of course the complaint alleges that La Quinta employees had failed to clear the area of snow and ice.
Well, the proof that we would be looking at would be the statement of undisputed facts and your response to dispute some facts and admit some and assert other undisputed facts. So I think that's what Judge Dinkins is inquiring about.
I would just have to rely on what is in those statement of undisputed facts.
All right, very good.
One other thing I need to mention before closing, though, is on this duty to warn. And the law in Tennessee is that a landowner, property owner does have a duty to either remediate the dangerous condition or to warn about it. And in this particular case, La Quinta did neither. And so we say that they either failed to remediate it, or they failed to warn about it, and since they did neither, that they're liable under probably both of those theories.
Wasn't your client warned by his own sensory skills when he pulled into the parking lot in his car and opened the door and stepped out and stepped into 2 inches of snow?
Well, there's nothing in the record that indicates that he stepped on ice. He fell on ice. He didn't fall on snow, Your Honor. And so, no, I don't think so.
All right, thank you. All right, your time is up, and we appreciate you, Mr. Judkins and Mr. Embry, for your arguments. And that concludes the hearing of this case. Mr. Hibner.
This honorable court is now in recess until 11 a.m.
Thank you.